Do you obsess over cold cases?
Do you go down endless rabbit holes on online forums, searching for clues to solve your pet case?
Are you an armchair sleuth? If so, we'd like to invite you to check out our new podcast, Citizen Detective.
I'm Mike Morford.
I'm Nama Cates.
And I'm Dr. Lee Meller. We work hand in hand with citizen detectives just like you to examine some of the most puzzling unsolved mysteries out there.
Citizen Detective is out right now, and new episodes drop every other Saturday.
Subscribe now so you don't miss a single episode of Citizen Detective.
Hello and welcome to Reverie True Crime. I'm your host, Paige. Mississippi, where I was born, raised, and still live today. In the 1980s, 2.5 hours from where I live, elderly women were being murdered. These homicides followed one man, either by horrible coincidence or dreadful acts he carried out himself. Killings happened everywhere he went, even when he went out of state, but it was never known if all of the murders were actually committed by him. You'll have to form your own opinions as the story unfolds. Let's get started. Gregory Davis was born in 1966 in Jackson, Mississippi. Not much is known about his parents, except his father was a Baptist minister. When Gregory crossed the threshold into his adolescent years, he was obsessed with older women, sexually. The public library in Jackson is where Gregory would spend his time, but not to read books or study. He would take a seat and stare at women. After a while, he would get up, traipsing over to a book aisle and reaching through the books on the shelves to the other side, touching and filling up unwary women who were simply looking through books to check out. They never anticipated they'd be so violated and frightened while simply browsing books at the library. In 1985, the month of January, many women had made complaints about the almost 20-year-old young man who was creeping around on the floor, peering up their skirts and feeling up their legs. A librarian finally called the police, and Gregory was taken into custody for disorderly conduct. When he was arrested, the police pat him down and searched him. They found 2 credit cards he had pocketed. Gregory was embarrassed that not only did everyone find out about his behavior, but being arrested on top of it all and charged with misdemeanors. He was so mortified that it wasn't long before he packed up his belongings and moved to Georgia. In Albany, Georgia, he joined the Job Corps. Just because Gregory moved to another state didn't mean his ways had changed. While he was attending classes at the Job Corps, he would drop his pencil on the floor so he could crawl under the desks and feel up the legs of his female classmates. Reportedly, he took his penis out of his pants once during class. The police began to blame the head honchos of the Job Corps of keeping Gregory's inexcusable conduct a secret to avoid any flack and humiliation. 1 block away from where the warehouse was, where novices of the Job Corps would stay, a gruesome murder occurred. It was October 17, 1986, when 59-year-old Lucy Spillers had been strapped to the foot of her bed with a rope stringently bound around her neck. She also had been mutilated sexually with a butcher knife. Murders seemed to transpire no matter where Gregory went. Did these awful incidents just happen to take place around him by coincidence? Or was he committing these heinous atrocities himself? Gregory moved back to Jackson, Mississippi sometime in November of 1986. On November 18th, Mary DeWitt, 81 years old, was inside of her home like any other day, but this day would sadly be her last. An intruder came into her house, attacked her, sexually assaulted her, and beat her until she died. On December 11th, 83-year-old Bertha Tanner died the same way in her home. A few months went by until any killings happened again. Addie Reed, 80 years old, had her life taken from her on March 31st, 1987. Stick a pin in this one. We will come back around to what happened to Addie Reed. A few days before Addie's brutal death, another woman, who was 74 years old, had been viciously attacked. Luckily, she managed to make it out alive. She was able to go to the police and share with them the best depiction she could of the perpetrator who assaulted her. Another month would go by with the killer on the loose before law enforcement would find out who did this to her and possibly the other women as well. Gregory Davis broke into a home to take anything he could on April 17, 1987. He slipped up and left a trail of evidence that would result in his capture 3 days later. By May 1st, Gregory was charged with 3 counts of murder and 1 assault in Jackson. The police in Albany, Georgia, were gathering up the charges there in the case of Lucy Spillers. Now we will circle back around to 80-year-old Addie Reed. On March 31st, 1987, around 7 in the evening, Gregory decided to go visit one of his friends on Manship Street. When he got to his friend's apartment, he wasn't home. Gregory strolled next door to Addie Reed's home. She was a widow and all alone. Gregory began to check Addie's doors and windows to see if anyone was home or if anyone was there with her. The first thing he did was unscrew her light bulb, which shined brightly on her front porch. Gregory crept around to the back of Addie's home. He used a small table to lift himself up and crawled through her unlocked bedroom window. Finding Addie's purse, he took around $10, and right before she came into the room, he quickly hid behind her bedroom door. Suddenly, she saw him. Addie was shaken up, in a state of fear and panic. All she could do was scream. Gregory pounced, hitting her numerous times in the face. Then, he put his arm around her neck and dragged her all the way from her bedroom to the dining room. After Addie died of asphyxiation, Gregory did what a lot of killers do when they can't look at what they've done. He draped a towel over her face. Before he left, he sexually assaulted her body. Strutting out of the front door with Addie's purse, a small flashlight, and a jewelry box in tow, Gregory walked up the street and stopped at a doctor's office. He tossed all of these things onto the rooftop of the office and went on about his way. The Jackson Police Department received a call on the 27th of April that there was a possible break-in and robbery that happened at someone's home on Bailey Avenue. A few officers fled to the scene. Gregory Davis and his younger brother, Thomas, were quickly arrested in the parking lot of the Jackson Mall. Gregory was put in a cop car with Officer Shirley Williams, who took him to the home, and the woman he attacked inside of her home positively identified him. Gregory was officially arrested. After he was read his Miranda rights, he waived them and was questioned for a short time about the robbery. He said he didn't want to talk. The questioning came to a halt. He was hauled off downtown to the city jail. The next day, Detective Charles Crisco saw that Gregory had been taken into custody for burglarizing a home. There were so many other things around the area going on that were so similar that the detective suspected they were all linked to Addie Reed's horrific killing. Detective Crisco and his partner, Detective Robert Jordan, walked Gregory into an interrogation room, read him his rights, and he waived them in writing. From there, the questioning began. First, Gregory was asked about the robbery on Bailey Avenue and other burglaries in the area. After he was somewhat more relaxed talking to the detectives, Detective Crisco gradually went into questioning him about the murder of Addie Reed. In the beginning, Gregory said he had nothing to do with her murder at all. Eventually, after more questions, he confessed that he had in fact killed her. The detectives had the tape recorder rolling, a transcript was made of his confession, and a police officer took a typed statement. Before the interrogation was over, there was one last step to take. Police officers took Gregory to Manship Street to the doctor's office, where he showed them where he threw Addie's things. They recovered the pink purse, flashlight, and jewelry box on the rooftop of the doctor's office. On January 13, 1988, Gregory's trial commenced in Hinds County, Mississippi, but eventually the trial was transferred to Forrest County due to pretrial publicity. He didn't testify, but he pleaded not guilty by insanity. Psychologists and psychiatrists gave differing testimony. The state tried to bring pictures into evidence, but the defense attorneys objected. They said the photographs were too gruesome, repetitive, and that bias as an outcome from the prosecution's opening statements would far exceed any emotional demonstrations the photos might have. Regardless, the trial court did let some of the photos in, not all. There were some post-autopsy pictures included in the batch of photos allowed into evidence. The confession Gregory made, which the defense objected to, would ultimately seal his fate. Today's episode is sponsored by Newsly. Newsly is an all-in-one audio super app for iOS and Android, providing the most popular trending articles on the internet on any topic you choose at any moment. Newsly will even read them to you in a human voice. The entire web becomes listenable in one place. So stop scrolling and start listening. Follow topics such as sports, business, science, Bitcoin, or any celebrity, and let Newsly read the most recent articles to you. Not only will you get articles, but Newsly also has all of your favorite podcasts from over 80 countries, including Reverie True Crime. Not only will you get news articles read to you and podcasts, but Newsly also has digital radio. You can download Newsly for free now at www.newsly.me. And if you want to try 1 month free of the premium subscription, use the promo code RTCM. All of this will also be in the show notes. Download Newsly today at www.newsly.me. And for 1 month free of the premium subscription, use the promo code RTCM. The jury only deliberated for 35 minutes before they found Gregory guilty of capital murder and agreed on the death penalty. Gregory did, of course, appeal. He assigned the following as errors. These are from public court records, and it includes more information about the trial as well. This appeal was submitted on July 26, 1989. The link to this appeal will be in the show notes. Also, you'll hear Batson versus Kentucky come up and Batson in general. This refers to the trial of James Kirkland Batson for burglary and receipt of stolen goods. The prosecutor insisted to remove all 4 African Americans from the jury pool. Batson challenged the removal of these jurors as violating his Sixth Amendment right to an impartial jury and the Equal Protection Clause of the 14th Amendment. The jury convicted petitioner on both counts. On appeal, the Supreme Court of Kentucky affirmed the convictions. The Supreme Court agreed to hear the case. It was ruled while a defendant is not entitled to have a jury completely or partially composed of people of his own race, the state is not permitted to use its preemptory challenges to automatically excuse potential members of the jury because of their race. The Equal Protection Clause guarantees the defendant that the state will not exclude members of his race from the jury veneer on account of race or on the false assumption that members of his race as a group are not qualified to serve as jurors. The harm from discriminatory jury selection extends beyond that inflicted on the defendant and the excluded juror to touch the entire community. Selection procedures that purposefully exclude Black persons from juries undermine public confidence in the fairness of our system of justice. A defendant in a criminal case can make an equal protection claim based on the discriminatory use of preemptory challenges at a defendant's trial. Once the defendant makes a showing that race was the reason potential jurors were excluded, the burden shifts to the state to come forward with a race-neutral explanation for the exclusion. So that is what it means when Batson is referred to. On Gregory Davis's appeal, number 1, did the lower court err in admitting into evidence Gregory Davis's confession? Before the trial, Gregory Davis filed a motion to suppress his confession, alleging that it was made as a result of coercion and in the violation of his constitutional rights. A hearing was held pursuant to this motion on December 21st through the 22nd of 1987. The first witness at the suppression hearing was Detective Charles Crisco. Detective Crisco testified that Gregory never at any time before questioning began on April 28, 1987, requested to speak to an attorney. Detective Crisco denied that Gregory had been denied food on the day of the interrogation, and also denied that Gregory had been threatened if he would not confess and promised help if he would. Gregory Davis testified next. According to him, after he was taken from Precinct 3 downtown to the city jail, he was not allowed to make a phone call. He was fed on the morning of April 28th and was given nothing else to eat until that night, after he had confessed. Gregory said that Detective Crisco and Detective Jordan began interrogating him at noon, and the interrogation consisted of threats and promises of help if he would confess. Gregory alleged that at one point, Detective Crisco threatened to have him electrocuted if he would not confess. He maintained that at this point, he first asked to speak to a lawyer. He said that Detective Crisco told him that he could speak to a lawyer if he would sign the form waiving his Miranda rights. Gregory signed the form, but still was not allowed to make a phone call or see an attorney. According to Gregory, Detective Crisco also promised him help from a judge if he would confess. Gregory never testified that he asked to speak to a lawyer when he was first arrested at Precinct 3 on April 27, 1987. Dr. Shalton Stanley, a psychologist, and Dr. Timothy Summers, a psychiatrist, both evaluated Gregory for the defense. Both found that Gregory was paranoid schizophrenic, and that under the interrogation conditions that Gregory had alleged, his confession would have been the result of impaired judgment and involuntary. Dr. Stanley testified that under the conditions that Detective Crisco had sworn to, his opinion would be different. Dr. Summers testified that even under optimum conditions, if Gregory was surrounded by authority figures such as police, his confession would be involuntary. Dr. Rodrigo Galvez and Dr. Michael Whelan testified for the state. Both found that Gregory Davis had a personality disorder, but neither felt that he was a paranoid schizophrenic. Both felt that he was competent to waive his rights knowingly, intelligently, and voluntarily. Sergeant Cleon Butler, who was assigned to the burglary division in April of 1987, was at Precinct 3 on April 27th when Gregory was arrested. Sergeant Butler stated that he questioned Gregory about the burglary for about 5 minutes, and then Gregory told him that he didn't want to talk about the burglary anymore, and that he wanted an attorney present. At that time, Sergeant Butler said that Gregory was transported to the city jail. On cross-examination, the defense counsel attempted to have Sergeant Butler elaborate on this request for an attorney. But Sergeant Butler's response was confusing and contradictory. The trial court felt the need finally to question Sergeant Butler on its own, and he repeated his statement that Gregory had asked for an attorney at Precinct 3 on April 27th. After the sergeant's testimony, 4 other police officers who were at Precinct 3 on April 27th, none of them recalled Gregory asking for an attorney, and some who claimed to be with Gregory during the entirety of his stay at Precinct 3 stated affirmatively that he did not ask for an attorney at any time. Both Detective Crisco and Jordan were recalled, and both said they had spoken to Sergeant Butler after Gregory's arrest. Both of them agreed that Sergeant Butler had said nothing about Gregory requesting an attorney. The trial court issued its own opinion on January 4th, 1988. It made the following findings of fact. Number 1. Gregory Davis did not exercise his right to an attorney through Sergeant Butler, and that Sergeant Butler's testimony is the result of an honest mistake. Number 2. Gregory Davis terminated the interview at Precinct 3 with a statement that he did not desire to discuss the burglary any further. Number 3. Gregory Davis had the capacity to and did understand his rights as set out in the Miranda decision, that he was fully advised of those rights and that he freely, voluntarily, and intelligently waived those rights. Findings by a trial judge that a defendant confessed voluntarily and that such confession is admissible are findings of fact. Such findings are treated as findings of fact made by a trial judge sitting without a jury as in any other context. As long as the trial judge applies the correct legal standards, his decision will not be reversed on appeal unless it is manifestly in error or is contrary to the overwhelming weight of the evidence. The trial judge determines, in view of the totality of the circumstances, whether or not a confession was made voluntarily and whether there was a knowing and voluntary waiver of the accused privilege against self-incrimination. The state has the burden of providing all facts prerequisite to admissibility beyond a reasonable doubt. We find that the trial judge's findings of fact were not against the overwhelming weight of the evidence and were not manifestly in error. Sergeant Butler, who played a minor role in the jailhouse scenario, was the only officer who stated that he heard Gregory ask for a lawyer at Precinct 3, and his testimony is confusing and shallow. Gregory Davis never testified that he asked for a lawyer at Precinct 3. His own testimony first mentions a lawyer, according to the record, at the time that he mentions the alleged electrocution threat by Detective Crisco on the afternoon of April 28th. As to the alleged threats and coercive tactics used by Detective Crisco and Detective Jordan during their interrogation of Gregory, it should be noted that he told at least two different versions of this session, that his own doctors testified that he was happy in jail and when he was causing his parents difficulty, and that none of the threats showed up on any of the tapes made of the session. Detective Crisco and Jordan admitted that they lied to Gregory concerning the evidence in their possession. Although this is a factor to be considered when reviewing the voluntarity of the confession, it should be viewed in the totality of the circumstances. This assignment of error is without merit. Number 2. Was the defendant denied equal protection by the use of decisive challenges by the state? Gregory Davis is black. He argues on appeal that the state used its preemptory challenges in an unconstitutional manner to exclude potential black jurors from the jury. The jury, which was eventually seated to try Gregory, was composed of 4 men and 8 women, all white. The state exercised 12 preemptory challenges, 7 of which were used to exclude black persons from the jury. Batson requires a defendant, in order to make out a first impression case of purposeful discrimination in the selection of a jury, to establish, number 1, that he is a member of a knowable racial group, number 2, that the prosecutor has exercised dictatorial contest to remove from the jury members of the defendant's race, number 3, that these facts and any other relevant circumstances raise an inference that the prosecutor used that practice to exclude the potential or actual jurors from the jury on account of their race. Once this first impression has been made, the burden shifts to the state to come forward with a neutral explanation for challenging black jurors. Though this requirement imposes a limitation in some cases on the full preemptory character of the historic challenge, we emphasize that the prosecutor's explanation need not rise to the level of justifying exercise of a challenge for cause. But the prosecutor may not rebut the defendant's initial impression case of discrimination by stating merely that he challenged jurors of the defendant's race on the assumption or his intuitive judgment that they would be partial to the defendant because of their shared race. Nor may the prosecutor rebut the defendant's case merely by denying that he had a discriminatory motive or affirming his good faith and making individual selections. The prosecutor therefore must articulate a neutral explanation related to the particular case to be tried. The trial court then will have the duty to determine if the defendant has established purposeful discrimination. In the case at bar, counsel for Gregory Davis objected after each potential black juror was struck. The trial judge found there was no pattern of elimination of black jurors, as the state had also excused 5 potential white jurors through peremptory challenges. Out of an abundance of caution, because this was a capital murder case, the trial judge required the state to justify the challenges. The state complied as follows. Number 1. We objected to Mary Duncan based upon the fact that all parties, including the court, have stated that the trial will last in excess of a week, and she's an elderly black female, just she's an elderly person who was born in April of 1916, and also she lists that her organizations to which she belongs, fraternal service, charitable, etc., are choir deacon, a minister's wife, and the Mission Sunday School. She says that her favorite reading material is the Hattiesburg American, her Bible, and the Reader's Digest. She says that her husband is Reverend McKinley Duncan, and he has been a minister and pastor, and that they've been married for 57 years. Number 2. We objected to Hazel Bournes. The state challenges her because she stated on her form that she was against the death penalty. It was quite evident that for some reason that she never gave, and which we were never able to determine, that she suddenly changed her mind once she realized what was happening. That is, we were letting jurors off who were against the death penalty, and overnight she suddenly became in favor of the death penalty. And we object because of her vacillation and because she originally, in her first impression, was that she was against the death penalty. Number 3. We object to Ernest Connerly, based on the same reason that we gave, that is, suddenly Ernest Connerly, when he realized that this was a death penalty case and might be excused from the jury for being opposed to the death penalty, changed his original impression that he wrote on his jury information questionnaire when asked what is his opinion of the death penalty. I don't believe in the death penalty, he wrote. Suddenly, without any explanation, he changed his mind overnight and said, "Oh, yes, I could vote for the death penalty." In addition to that, he said that he could not properly read or write, and he had to have a friend help him in filling out the form, and there will be a request by the state that the jury be allowed to read along a transcript of a tape that is a vital portion of the state's case. And in addition to that, the juror said he couldn't properly serve in this case due to his inability to read and write. Number 4. My first note that I wrote when I saw Hollis Hall walk into the courtroom was, quote, sullen, and I never changed it. I never changed my opinion from the date that I saw her first until she last left this courtroom. Every question I asked her, she answered in a hostile manner. She gave no opinion when asked what her opinion of the death penalty was, and for that reason, the state had to request an individual preliminary exam of her, and it was obvious to the state that she was hostile during that individual examination. And we also object on the fact that she is a divorced single parent. Number 5. We objected to Johnny Horn based upon the fact, there's one thing I left out. On Ernest Connerly, I'd like to further state another reason we object to him is that he stated that he talked with Johnny Horn outside the presence of the court with regard to matters that were going on in the courtroom. For the same reason, we object to Johnny Horn because he stated he talked outside the court regarding matters that went on inside of the court, and we previously voluntarily admitted that that was grounds for a juror to be excused, and excused a white female who said she was in favor of the death penalty. In addition to that, Johnny Horn has a first cousin on parole now, who was charged with killing someone and received a life sentence. In addition to that, Mr. Binder stated in front of the juror that like the record to reflect that he's black and that we'd called him in here because of his race and he could be prejudiced against the state based on that. In addition to that, when questioned about the death penalty, he stated he possibly could vote for the death penalty, but if he did, he would suffer from remorse, and he refused to fill out the form when asked what his opinion of the death penalty is. In addition to that, he belongs to no social, fraternal service, or charitable organizations. He is single. That is all. Number 6. In all deference to the court, Bernice McNair stated unequivocally that she could never vote for the death penalty if the defendant has a mental problem. I have on my notes that she stated that she was not in favor of the death penalty, although she said that wasn't true. Number 7. Objected to Geneva Hopkins, based on the fact that she sat on a jury on June of 1987 on a child molesting case which involved a sexual misconduct which resulted in a mistrial. She lists no social, fraternal service, or charitable organizations other than Mission. The trial judge found that the reasons specified by the state were acceptable. Such findings are entitled to great deference from a reviewing court. This court has adopted the clearly erroneous overwhelming weight of the evidence standard when reviewing such findings. Considering this standard of review and after careful scrutiny of the record, we find that the trial judge's findings are not clearly erroneous. The reasons supplied by the state are neutral, related to the particular case tried, and supported by the record. While these peremptory challenges may not have sufficed as challenges for cause, Batson clearly states that they are not required to rise to that level. The challenges presented by the state here are well within the perimeters of the Batson guidelines as interpreted by this court. Batson in no way prevents exercise of a determined challenge for a non-race-based reason that objective and fair-minded persons might regard as absurd. Gregory also argues that the state challenged black potential or actual jurors for reasons that were valid but not used against white potential or actual jurors, and the record reflects that this is accurate. Examples of jurors being challenged and others who were not: Mary Duncan was challenged in part because she was a preacher's wife, but a white minister was not challenged. Johnny Horn and Ernest Connerly were challenged in part because they discussed the case during first impressions, while white veneermen, who also discussed the case, were not challenged. While such use of challenges is a factor that may be considered by the trial court, in this case there were other reasons given which were adequate under Batson besides these disputed ones. Gregory Davis further argues that he was not allowed to rebut the reasons for the decisive challenges provided by the state, and if he had been allowed to do so, he could have shown that the reasons were not well-founded and had a discriminatory purpose. After the first 2 blacks were struck by the state, counsel for Gregory asked the trial court to require the state to justify the strikes. The trial court required the state to put forward its neutral explanations. After the state had finished, counsel for Gregory asked to make a record on this. The trial court replied, "Well, what record do you want to make? It's what the prosecutor considers their reasons." Defense counsel alleged that the reasons were inadequate under Batson. The trial court replied, "If there is a conviction, it will probably be reviewed." It is clear from the record that counsel for Gregory was given his opportunity to make his record. He could have made an offer of proof after the neutral reasons were supplied by the state, but instead only alleged in general terms that the strikes exercised by the state amounted to a Batson violation. The defense may rebut the neutral, non-racial explanation for preemptory challenges, but in the instant case that the defense offered no such rebuttal. In the absence of actual proffer of evidence concerning this issue, this court may not reverse on this point. While this court intends to be sensitive to the possibility that reasons given for challenging prospective jurors may actually be for racially discriminatory purposes, it is incumbent upon Gregory to come forward with proof when given the opportunity for rebuttal. In the case, there was a weak suggestion of rebuttal and a stated desire to be heard in rebuttal, but there was no proffer of evidence, no words of rebuttal. The Batson court specifically declined to create a procedure to be followed by trial courts in dealing with this question. Considering that later federal cases have declined to issue per se rules to be followed when a Batson challenge arises, and considering that the procedure followed by the trial court in case at bar has been previously allowed by this court, we find that there is no error here, either in the trial court's findings or in the procedure followed. Number 3. Did the admission of certain photographs deny Gregory Davis his due process right to a fair trial? Gregory argues that certain photographs of the deceased introduced by the state were so gruesome and prejudicial that they in part resulted in the failure of Gregory to receive a fair trial. Defense counsel made a contemporaneous objection at the introduction of each photograph. The admission of photographs into evidence is within the discretion of the trial judge, and such admission will be upheld on appeal absent of showing an abuse of that discretion. If photographs are relevant, the mere fact that they are unpleasant or gruesome is no bar to their admission in evidence. However, photographs of the victim should not ordinarily be admitted into evidence where the killing is not contradicted or denied, and the corpus delicti and the identity of the deceased have been established. Photographs of bodies may be admitted into evidence in criminal cases where they have demonstrative value and where they are not so gruesome or used in such a way as to be overly prejudicial or inflammatory. In the case at bar, the defense admitted that Gregory had killed Miss Reed, so there was no need to establish the identity of the killer or the victim. It appears that the exhibits have some probative value, and although they are extremely unpleasant, they do not appear to be as gruesome as some photographs described in other cases. The trial judge did sustain defense counsel's objection to certain post-autopsy photographs which the state tried to introduce. Also, once the photos were in evidence, counsel for Gregory used them to elicit reactions from Gregory's parents on direct examination. This assignment of error is denied. Number 4. Was the verdict of guilty against the overwhelming weight of the evidence? Gregory Davis maintains that the finding by the jury that he was McNaughton sane at the time that he murdered Addie Reed is against the overwhelming weight of the evidence. McNaughton sane is where a person is not insane at the time of the killing. McNaughton insane is when the person was insane at the time of the murder. Dr. Charlton Stanley, the psychologist, and Dr. Timothy Summers, the psychiatrist, testified for Gregory. Dr. Stanley found that Gregory was paranoid schizophrenic. Dr. Summers found that Gregory suffered from a borderline character disorder, seizure disorders, and had a schizophrenic-like psychosis. Indeed, Dr. Stanley, in a written report, found Gregory to be McNaughton sane, and held such a belief until 1 hour before he testified. Only then did he testify that he finally concluded that Gregory was McNaughton insane. Both found that Gregory was McNaughton insane at the time of the murder. Dr. Michael Whelan, a psychologist, and Dr. Rodrigo Galvez, the psychiatrist, testified for the state. Both testified that Gregory has a personality disorder. Dr. Whelan added that Gregory showed avoidant, dependent, and passive-aggressive tendencies, but that Gregory was not psychotic. Both found that Gregory Davis was not McNaughton insane. This jurisdiction continues to follow the McNaughton rule on insanity. The rule has been stated as follows. To establish a defense on the ground of insanity, it must be clearly proved that at the time of committing the act that the accused was laboring under such defect of reason from disease of the mind as not to know the nature and quality of the act he was doing, or if he did know it, that he did not know what he was doing was wrong. The defendant is believed sane until a reasonable doubt of his sanity is created. When such a doubt arises, the burden is then placed upon the state to prove beyond a reasonable doubt the defendant's sanity. The issue of a defendant's insanity is a determination for the jury to make, and the finding will not be reversed if it is supported by substantial evidence. In making this determination, the jury may accept or reject expert and lay testimony. A finding that one is mentally ill does not necessarily mean that one is McNaughton insane. In this case, the jury had an opportunity to judge the credibility of both sides' experts. The jury obviously found that the state's experts were more credible, and such a finding is supported by the record. The jury's determination was not against the overwhelming weight of the evidence, and this assignment of error is without merit. Finding no reversible error here, as with the preceding assignments of error, we affirm both the conviction of capital murder and the sentence of death. Conviction of capital murder and sentence of death affirmed. Wednesday, September 20th, 1989, set as date for execution of sentence in the manner provided by law. Robertson, Justice, concurring. Quote, "What has happened in this case is fundamentally, morally wrong. A black man charged with the capital murder and sexual brutalization of an elderly and apparently defenseless white woman has been put on trial for his life before an all-white jury. A jury seated after the prosecutor was allowed to strike all 7 black potential jurors. And it was so unnecessary. On this evidence, a jury of 12 cerebral eunuchs would have convicted. Still, I can but affirm, the enforceable positive law, as I understand it, allows what the record reflects has occurred. Though I have no doubt much of our law has its moorings in notions of political morality, I have always thought it a virtue that the judicial mind keeps before it the proper distinctions between law and ethics, and enforce the latter only in so far as it may be reflected in the former. There was once hope, and but recently. When the sun set on April 30th, 1986, the Supreme Court had declared unlawful, purposeful use of preemptory challenges to exclude black persons from jury service. It is true that Batson paints with a broad brush. From the clear view hindsight so often provides, our law job was to hang flesh upon Batson's skeletal frame, to be sure, to fit it within the fabric of our law of criminal procedure, but to do so in a way that both fits the Batson text and justifies Batson as a political and moral judgment legislated by a superior and authoritative lawmaker. A judgment founded upon the realities that substantial and invidious racial discrimination was being practiced in jury selection, and that this was a state-sponsored sin, and that 2 decades' experience had shown an inept antidote. If anything is clear, it is that Batson was meant to change things, not just form, but substance. The American federal judicial system works only to the extent its 50 partners in the main accept with good cheer the supremacy clauses so easily evaded mandate. I would have thought a clarion call that we really mean it, yet history records that Batson's effect was quickly eviscerated. Except a prosecutor dim-wittedly confess his discriminatory purpose or offer no reason at all in support of his strike, he may with exemption exclude black jurors to the limit of his preemptory challenges. Our positive post-Batson law, as I perceive it, accepts that any pretext will pass for a racially neutral reason for exclusion. We have held that Batson in no way precludes exercise of a preemptory instruction challenge for a non-race-based reason that objective and fair-minded persons might regard as absurd, an utterance for which I bear no small burden. Our law has unleashed and exalted the Batson-recognized fact as to which there can be no dispute. That dictatorial challenge constitutes a jury selection practice that permits those to discriminate who are of a mind to discriminate. But a step back from our legal blinders and into the world of common sense reveals a different picture. The pretense that the prosecutor had in mind racially neutral reasons for striking each and every one of those 7 black potential jurors may but call to mind the eerie atmosphere of Never Never Land, in which a former Attorney General of the state once urged, and a U.S. District Court once found, that Mississippi had no official policy of racial segregation. Little beyond common sense is required to perceive the virtually non-existent statistical probability that the prosecuting attorney below, in fact, exercised the 7 preemptory challenges at issue for neutral, non-race-based reasons, a point I have offered before without effect. Enforcement of Batson's paper right has simply not been forthcoming. I can but think of Holmes's utterance from another context. Legal obligations that exist but cannot be enforced are ghosts that are seen in the law but that are elusive to the grasp. Because the day is late and we are bound by our post-Batson examples, I see no choice but to do expressly what the majority does implicitly. Pass the buck from which it came, to the Supreme Court of the U.S., with a plea that Batson be overruled or given teeth." End quote. Sullivan, Justice, concurring. Quote, "First, I concur in the opinion of the majority, and with much of what is said in the concurring opinion of Robertson J. I write separately because in my view, our short history of Batson v. Kentucky in 1986 convinces me that Justice Marshall's concurring opinion in the case was the correct approach to the abuse of hasty instruction. I know of no valid reason why a citizen of this state should be removed from a jury without any cause being given simply because one side or the other did not want that citizen to sit on the jury. It appears to me that the most open and honorable solution to the problem is to do away with the preemptory challenges in criminal cases, both for the prosecution and for the defense, and allow a juror to be challenged only for good cause shown. Therefore, I would like to affirm the conviction and sentence in this case, and declare an end to all preemptory challenges in all criminal cases tried in the courts in the state of Mississippi from this day forward." End quote. Notes. Number 1. Although it was raised as an issue by neither side whether Gregory Davis's invocation of his right to remain silent should have any effect on the admissibility of his confession has been considered by this court, we find that Davis's right was scrupulously honored. Apart from the problem of today's case, we indefensibly held defendants to procedural burdens from which the prosecutors were exempted. Number 2. One point of Batson procedure has been saved, and I applaud the majority for recognizing it. Our cases do say, once the prosecutor has tendered his reasons for challenge, the defense may rebut. Nothing in Batson or our cases precludes the defense from attempting to show the prosecutor's reasons as false or sham. The point, however, avails Gregory Davis nothing on this record. After the prosecution gave its neutral explanations, counsel for Gregory asked to make a record on this. The trial judge replied, quote, "Well, what record do you want to make? It's what the prosecutor considers their reasons." End quote. Defense counsel alleged that the reasons were inadequate under Batson. It appears quite clear the circuit court misapprehended this point of Batson procedure, and had Gregory Davis tendered us a record that even halfway suggested he had a meaningful rebuttal to make and was denied the same, I would reverse. If Gregory had tendered a rebuttal, the court would have been obligated to hear it. Gregory Davis's record is deficient, and no reason appears why we ought to exempt him from the rule. Again, the forms require affirmance." End quote. The rehearing was denied September 27, 1989. Gregory did appeal again on March 16, 1995, requesting to vacate the death sentence and asked for a new sentence hearing. The rehearing was denied on June 22, 1995. He is still in Parchment Prison in Sunflower County, Mississippi. And that concludes today's episode. Thank you so much for listening, and until next time, stay safe and take care.